Court. I'm David McCraney. I'm here on behalf of Russell Menshouse, the claimant in this workers' compensation case. I assume that the Court is aware of the facts of the case, so I'll just say briefly that it involves an accident wherein Mr. Menshouse was injured while working on the vehicle of a co-employee, Mr. Shugart, after normal business hours of Atlantic Automotive. The Judge of Compensation Claims denied the compensability of the claim, finding that it was not an accident arising out of and in the course of Mr. Menshouse's employment under 440.02 subsection 36. Perhaps the main point that the carrier uses to defend the order on appeal is whether Mr. Menshouse had permission to perform this particular activity, and so I'll try to address that.
Well, counsel, before we get to that, you've asserted that we have here a de novo standard of review, if I understand. Don't we really have a mixed standard of review here? Because it seems to me the central question was a question of fact, and that is whether the claimant was required to obtain permission before working on his or another employee's vehicle, and that's a fact issue that was decided by the JCC, with respect to which we've got a competent substantial evidence standard. Isn't that correct?
Well, Your Honor, the judge didn't decide whether Mr. Menshouse was required to have permission. She made no factual findings on that.
Isn't it implicit in the order that I'll forget the exact language of the order, but it seems to me she did find the claimant did not have permission to do the activity. Isn't it implicit in that the permission was required?
I think it depends on what kind of permission you mean, Your Honor. If the court or if the JCC meant that he didn't have the express permission of Mr. Herring to do this, then that's correct. The evidence is undisputed that Mr. Menshouse didn't have the express permission of Mr. Herring to do this. But the question is whether, because of its practices, Mr. Menshouse had the implied permission of the employer.
Isn't that also a question of fact?
She didn't make any factual findings on that either, Your Honor. The court simply said that Mr. Menshouse didn't ask permission and that he didn't have permission. But that gets into also the point that I wanted to make, which was we can't tell from the record exactly what Atlantic Automotive's policy was on this to begin with. It's not clear by any means that the individual worker had to obtain the permission of the employer to perform this after-hours work, or whether it was simply the job to be done that you had to get permission to do.
But whose burden was it below? Was it the claimant's burden to prove his case, or was it the employer's burden to disprove the claimant's case?
Well, obviously, it's the claimant's burden to prove that his accident arose out.
So if it's not clear, who bears the risk of non-persuasion in that situation?
Well, I think that, well, again, I believe this is a question of law, because even if the court assumes that he didn't have permission and that he was required to get permission, I don't believe that the issue of compensability should turn on that question. There are many cases from the court, particularly I'll cite to the court the horseplay cases, where there was a direct violation of some company policy, and yet the court found that the accident was compensable anyway.
But that's because they were actually working at the time. They were on the clock working in the horseplay cases.
That is true, but there are other cases, as the court well knows, where a person doesn't have to actually be on the clock before an accident will be held compensable.
If they're actually doing duties preparatory to performing their work.
Well, again, I think if the court will refer to the Vigliotti case, the Perez cases, all those cases having to do with the fact that the claimant was on the premises when they were injured, none of those individuals were on the clock. I know that, as I recall, the Vigliotti in the case and the Perez case and the Bechtel Construction Company case specifically, they had clocked out for the day. They weren't doing anything that was preparatory to their duties. Now, they were obviously doing something that was incidental to their duties, all of those cases, and Mr. Menshouse was as well. He was using company facilities and company equipment and company supplies to do work that this employer routinely permitted his employees to do.
Not according to the employer. The employer said he had to get permission and he didn't do it.
He said also that he routinely granted permission and that he would grant permission if it was a minor job, or unless he was not going to be on the premises, he would grant permission. He said that there were times when he had denied permission, but he didn't cite any specific examples of when he had denied permission. And in fact, he didn't say that he would have denied permission to Mr. Menshouse if he had been asked. So I don't think that the question of compensability should turn on whether or not Mr. Menshouse did or did not obtain the express permission of this employer, even if he should have obtained that permission. I think that allowing the question of compensability to turn on questions like that injects notions of fault into the workers' compensation system, which is supposed to be a no-fault system.
Doesn't it inject notions of whether, in fact, the individual was in the course and scope of his employment and therefore workers' compensation applies at all?
Yes, obviously, that's what we're here about today.
Isn't that central to this case?
Yes, Your Honor, it is. I mean, that's the question. Was this an accident arising out of and in the course of his employment?
And as Judge Van Norwick suggested earlier, isn't that, in fact, a mixed question of law and fact?
I haven't seen cases addressing whether or not a situation like this would be a mixed question of law and fact. The closest one that I've seen, I cited in the brief, I believe it was the Wilson case, where they said that if the facts are undisputed, then the question is a question of law as to whether those facts meet the statutory definition of arising out of.
What does that suggest to you the result would be if the facts were disputed?
If the facts were disputed as to some pertinent issue concerning the question of compensability, then that would mean that the competent substantial evidence should apply.
But back to my initial question, it seems to me we have the claimant testifying, if I understand the record correctly, that permission was really not needed in every case, and we have the employer testifying that permission was needed in every case, although he granted it almost every time. It seems to me that's a classic factual dispute, isn't it?
That is a factual dispute, yes. But that factual dispute should not be the deciding point of the case. Again, getting back to, suppose that Mr. Menshouse agreed that he should have had permission here and that he didn't do it, and that he deliberately violated some company policy. I don't believe that that means that, therefore, his accident is not compensable. Maybe that gives the employer some grounds to discharge him from his employment, but the question of whether he suffered a compensable accident shouldn't depend upon.
But it relates to the course and scope of employment, doesn't it, as Judge Webster asked? And it seems to me you cited the Evans case in your brief, and in that case, the judge of compensation claims found that there was implied permission, and this court agreed that there was implied permission, and as a result found that the claimant's injury arose out of and in the course of his employment. So it seems to me that's the issue. I mean, I thought that case was was pretty close to being on point, except factually they came down on the other side, said there was implied permission, and here, at least implicitly, the JCC has found that there was no permission. Admittedly, the JCC here did not go into detail about that, but you have to read that, at least I would have to read the JCC's finding in that regard.
Well, if the court believes that this case should turn on a question of implied permission, and the JCC did not make any factual findings on the issue of implied permission, then perhaps what the court should do is to remand the case to the judge of compensation claims to make findings on that issue so that the court could review it. But again,
just exactly what does the claimant was off work, did not have permission to, and there's a word missing there, to, I guess, perform the activity, was not paid, was not acting. What does all that mean if it's not a finding that he didn't have any kind of permission?
I don't believe that it means that she found that he didn't have the implied permission. She simply made no findings of fact about the course of dealing here, about how often Mr. Herring would grant permission, under what circumstances he would deny permission.
So saying that he did not have permission could actually mean he did have permission.
I think it could mean that he did have the implied permission of Mr. Herring. I think it's an ambiguous finding. If you start talking about implied permission, and she didn't specifically address whether he had implied permission, then I think that it's ambiguous whether or not she made a finding of implied permission here. I see that I'm into my rebuttal time, so I'd like to reserve. Thank you.
May it please the Court, my name is Alexander Singenis, and I represent the employer carrier appellee in this matter. As you were discussing, Your Honors, I do believe that this is a mixed case. There were some issues of fact which were in dispute in the underlying case, and as such, any findings of fact that the JCC should be upheld if there was substantial competent evidence.
Excuse me, counsel, have you made an appearance in this case?
Yes, I have.
Did you file a notice of appearance?
Yes.
When did you do that?
It was filed about a month ago, sir.
Okay.
I didn't notice
because I don't know that any of us is aware of that.
All right.
Could you tell us your name again?
Sure. Alexander Singenis, S-A-N-J-E-N-I-S.
And would you check on your way out after the argument to make sure that they have it? Thank you. I'm sorry. Go ahead.
I did see it filed in the online docket.
Okay.
But I can double check to make sure. Your Honor, so there is a mixed issue of fact and of law here, and any factual findings by the JCC, as you said earlier, should be upheld as substantial competent evidence. Specifically, I think there are 4 factual findings here, and I'll briefly review the factual findings as I do think they are relevant to this case. One, which is not in dispute, is that this injury occurred after work. The exact time after work is not certain, but based on the testimony of the witnesses and police reports, it's believed that it was about 25 minutes after work had ended. The next factual finding by the JCC was that it was not incidental to work, in that the claimant was not exiting the premises, the claimant was not cleaning up his workspace, he wasn't putting away his tools, he wasn't talking with his supervisor, he was not engaged in any activity which is otherwise incidental to work. The other factual finding was that there was no benefit to the employer. In fact, I think in the underlying file, the underlying record, benefit to the employer was never even discussed. It was known that employees were, with permission of the employer, allowed to use the facilities, but there was never any specific discussion over whether there was a benefit to the employer. And the JCC found, since that burden had not been proved, that there was a benefit to the employer, found in her order that there was no benefit. And lastly, as the JCC found, there was no permission from the employer.
Counsel, refresh my memory. Was it argued that the type of employer benefit that was found in the Evans case existed here? That is, employee morale would be lifted if the employees could work on their vehicles in this situation?
Your Honor, based on my recollection of the record, there was no discussion, any discussion of benefit. And as you said, that is a burden that should be proved because, as the extensive case law has shown, benefit to the employer has been a key factor in determining whether it's a compensable injury. And whereas the claimant did not satisfy the burden of even mentioning the benefit, there were ample witnesses from the employer who were brought up, and none were asked, was there any benefit to the morale? 3 workers actually testified, and none were asked, was there any benefit to your morale? And I do believe that burden would have been on the claimant in the underlying case.
And in fact, the judge made an express finding that the employer received no benefit.
Yes, exactly, Judge Webster. Very clearly delineated. There was no benefit. The claimant has also tried to use several avenues to reach compensability, as discussed extensively in the brief, but I believe if we look at each avenue, we realize that none of these avenues really support compensability. The one discussed extensively, and which is, in my opinion, the one most relied upon by the claimant, is the premises rule. And there's no dispute that the claimant was on the employer's premises. However, when we look at the premises rule cases, we see that there was some preparatory, or I guess you could say post-preparatory or incidental purpose to being on the premises. In Perez and Vigliotti, the claimant had clocked out in both cases and was actually exiting the premises. And naturally, it's meant to protect the employee because the employee has to leave the premises. It's meant to protect the employee while she's exiting the premises. There's also some case law about discharged employees who were injured on the premises, but even those cases weren't really about the premises. It was more about a matter of protecting discharged employees from employer retribution. That way the employer can't discharge an employee and then say, oh, now you're no longer in the workers' comp system. The other avenue that was relied extensively upon in the claimant in the underlying brief was the implements and equipment of employment. He argued that he was using the employer's equipment, that he used the coolant, that I'm not a mechanic, but I don't understand the machinery myself, but there was certain machinery and equipment that was being used at the time. But I think if we take a look at the case, the implements and equipment of employment were not what injured the claimant. Ultimately, what injured the claimant was his coworker carelessly putting his car into drive and sending it slamming into the claimant. Another avenue which the claimant has been using to try to reach compensability has been the assisting coworker. And there were numerous cases discussed on assisting coworkers. Specifically one, which I believe Judge Van Nortwick, you discussed, was the Evans case. But there was a certain benefit that the employer and the employees would all receive, which was, in that case, the car had suffered a massive breakdown. I believe it was the engine had stopped working or the air conditioner had stopped working. And the JCC found that by helping that coworker, the injured employee was giving a direct benefit to the employer, because otherwise that employee would have to have taken time off from work to go take the car to an independent mechanic. In this case, although it was another mechanic and repair case, there was no finding which said that there was massive mechanical failure. The facts indicated was simply a routine maintenance, a coolant flush. Lastly, as discussed extensively, there was no benefit to the employer. And several cases which involve use of equipment of the employer and the premises rule show there must be some benefit to the employer. For example, in the Haddock case, which was relied extensively in the reply in the initial brief, the worker was injured while using he was a woodworker. He was building a nativity scene. He was injured while using one of the power saws, I believe. And it was revealed that the employer would allow that because they would take their employees' best projects and make like a sort of catalog and use that catalog as a marketing tool. And the court found that was the direct benefit to the employer. Also in the Wortman case, the Wardman case, we found that the boys were taking time off during the workday to jump into pools or lakes to cool off. And the court found that that was part of their personal comfort, and that by that personal comfort, there was a benefit to the employer because the boys were working outdoors. They were able to work better if they'd taken some time off to cool off. Also, several of the cases discussed extensively the importance of permission. And as the JCC clearly stated in her opinion, in her order, there was no permission from the employer. There was a factual dispute in the at the hearing about employment. Specifically, when the claimant was questioned on direct examination, he testified that permission was not necessary, that it was basically an implied permission. This contradicted his testimony in the deposition, which stated that you had to have the explicit permission of the owner, Mr. Herring, in order to use his equipment. Likewise, another witness, Mr. Wagner, testified that explicit permission was needed, and that everyone knew you needed explicit permission. And furthermore, the employer himself testified that it was explicit permission. And I do believe that permission is very important because the employer, by granting permission or denying permission, he's basically deciding is he going to assume the risk of what happens if someone is injured with this. The free-for-all, implied permission, I think is very dangerous to an employer because he ultimately wants to have control over what's going on in his job. And even Mr. Herring testified that he likes to know what's going on in his business.
Well, counsel, the counsel for the claimant argued that the issue of implied permission was not really addressed by the JCCs in her order, and that as a result, and that the order in that regard is, I think the word was vague, and that we should send this case back for a specific finding on that issue. How would you respond?
Well, I would disagree with that, Your Honor. The JCC's findings stated verbatim there was no permission. With regards to implicit permission, I believe the record extensively showed that explicit permission was necessary. And if explicit permission is necessary, then implicit permission is not sufficient. There has to be the actual authorization from the employer to use the equipment. And there was no dispute in this case that did not have explicit permission. And even assuming that we were in discussion of the implied permission, I think the record sufficiently shows there was no implied permission. The employer, Mr. Herring, testified that he was in his office doing payroll, that he had finished bringing up the last customer and went directly into his office to do payroll. From his office, he cannot see the bay where the workers were performing the cool and flush. And he only became aware of what was going on when he just basically heard everyone shouting. And he heard his exact words are, I heard a commotion. And he ran into the bay, and that's when he saw the claimant pinned against the wall in the truck. So, well, to answer your question, no, I do not believe we even have to reach implied permission because the record extensively shows explicit permission was necessary. But even if we were to discuss implied permission, I believe there are ample findings that there was no implied permission. In conclusion, Your Honor, the premises rule states that there must be some kind of preparation or incidental function to the employee being on the premises. As we've seen here, there was no incidental or preparatory function. This was at the close of the workday. This was a purely personal function. He was doing a cool and flush with somebody else. This was an unauthorized cool and flush. And I do not believe that the premises rule or any rule in workers' comp would permit compensability. Thank you.
Thank you. Mr. McCraney, you have a little more than 3 minutes.
Thank you, Your Honor. If the court were persuaded that this case should turn on an issue of implied permission, whether or not Mr. Menshouse had the implied permission of the employer to do this activity, even if he didn't have the express permission to do it, then I submit that the court should send this case back to the judge of compensation claims so that she could make some factual findings on that. Her sole finding was that Mr. Menshouse didn't ask permission to do this, that he didn't have permission to do this. Didn't say express or implied. And therefore, I think that if the court is persuaded that that's what this case should turn upon, then the court should have some better factual findings to work with. Mr. Menshouse was injured on the premises of this employer. He was using company equipment and supplies. It was within 25 minutes after this business had closed for the day. He was aiding a coworker at the coworker's request. He was doing something that he normally did as part of his employment duties, and that this is something that this employer routinely permitted. And given those facts, we submit that as a matter of law, Mr. Menshouse's accident should be compensable under the Workers' Compensation Act.
Thank you, Mr.
Thank you, Your Honor.
We're going to go ahead and take a break now. We invite you all to join us for coffee in the Commons, which is through the doors to your right. We'll be in recess.